Hello mga kamestro, welcome back to my channel and medyo natagalan tayo bago mag-vlog and sobrang busy and well, ngayon dahil may bagyo and wala tayong gagawin, mag-vlog tayo. Okay. So ito maganda pag-uusapan natin ngayon is pwede bang pagbigyan ng PCAB license ang mga foreign contractors? Ano sa tingin ninyo? Pwede bang bigyan ng PCAB license sa mga foreign contractors or it is only reserved to the Filipino contractors? Okay? So yun ang pag-uusapan natin ngayon. But before that, if you are not yet a subscriber to this channel or bago ka lang napadaan sa channel na to, mag-subscribe na, no? And recommend to your friends and click the notification bell so that you will be notified for my next content. And of course, huwag nyo na i-skip yung ads, no? Kasi sayang naman yung ads na nalagyan natin ng ads and i-skip pa natin. Okay? So, kung ready na kayo, then umpisahan natin yung ating discussion for this lecture. Hello mga kamestro, welcome back to my channel. And itong pag-uusapan natin ngayon yung magandang kaso, no? Kasi ang mga tanong palagi is pwede bang bigyan ng PCAB license ang foreign contractor, no? Halimbawa, hindi siya mag-joint venture, mag-apply siya ng PCAB license niya sa Philippine Construction Accreditation Board. Pwede ba? No? Or sa joint venturing, no? Pwede ba apply separately, no, yung foreign contractors for a PCAB license separate from the Filipino contractor entity, no, na makikipag joint venture. So itong case na to, itong case ng PCAB or Philippine Construction Accreditation Board versus Manila Water Incorporated. So ano nangyari dito sa kaso? Maganda yung kaso na to, no, a landmark case. And napaka-fresh pa nung kaso because it was only decided nitong March 10 yata or 11 posted sa website ng Supreme Court. So sa kaso na to, ang petitioner dito originally is the Manila Water Company Incorporated and the respondent is the Philippine Contractors Accreditation Board. And itong nangyari dito sa kaso na to, nag-file ng petition for declaratory relief, no, clarifying itong section 3.1 of Rule 3 of the Implementing Rules and Regulations of Republic Act 4566 or the Contractors Accreditation Law, no, or the PCAB law. So ang nangyari dito sa kaso na to ay noong July 9, 2012, ang Manila Water ay nag-seek or nag-apply ng accreditation ng kanilang foreign contractors to undertake a contract for waterworks and sewerage system. And then on November 8, 2012, 4 months after, PCAB replied, no, stating under Section 3.1 of RA 4566 IRR or the Philippine Contractors Law, sabi nung PCAB, regular licenses are reserved for and issued only to contractor firms of Filipino sole proprietorship or corporation with at least 60% Filipino equity participation, duly organized and existing under and by virtue of the Philippine laws. So yun ang sabi ng PCAB, no? So na-reject nila yung application for accreditation ng foreign contractors ng Manila Water Incorporated. PCAB pointed out that since the purported construction contract adverted to by the Manila Water do not appears to be a build, operate, transfer contract, hindi naman daw siya BOT contract, and therefore under RA 7718 or the Build, Operate, Transfer Law, hindi na kailangan ng accreditation pa ng PCAB ang isang foreign contractor, dahil ang project na ito, no, na pinapasok ng foreign contractor is not also a foreign assisted or finance project. So sabi doon ng PCAB na kahit hindi na mag-register, no, okay na, dahil allowed naman, dahil hindi naman siya pumasok doon sa provisions ng kontrata na gustong kontratahin ng foreign contractors, no. And in fact, it is also allowed by RA number 7718 or the BOT law. So the reason why this Manila Water Incorporated file for a petition for declaratory relief to determine the validity of the law, no, or the section 3.1 rule 3 of RA 4566 issued by PCAB, kasi ang implementing rules and regulations is issued by the administrative agency. Ito yung implementing guidelines ng basic law, no, ng RA 4566. So in the lower court, sa RTC, originally sa RTC na file yung petition for declaratory relief, the RTC ruled in favor of Manila Water. So nanalo yung Manila Water dito sa lower court, declaring section 3.1 of rule 3 of the IRR of RA 4566 as void. So nanalo yung Manila Water. Sabi ng RTC, it holds that the same does not merely interpret, no? Sabi ng RTC doon sa petition, it holds that the same does not merely interpret or implement the law, no? But PCAB creates an entirely new restriction that is not found in the law. While section 17 of RA 4566 allows the board to effect classifications, the same provisions requires the qualifications to be reasonable. The RTC believe that the classification affected by the IRR is unreasonable as it imposes additional burdens on foreign entities which are not found in the law or in the Constitution. No? Kasi ang lumabas yata is nag-create ng provisions sa IRR itong PCAB instead of having an implementing guidelines on the basic law. Diba meron tayong principle in statutory construction that the spring cannot rise higher than its source. So hindi ka pwedeng magdagdag sa IRR kung wala yan sa basic law. Kasi ang basis ng dapat ng IRR is gagawin niya or gagawa niya ng implementing guidelines kung ano ang nakalagay doon sa basic law. Okay? So PCAB filed a motion for reconsideration, but it was denied by the court. And then this is the time that PCAB becomes now the petitioner to the higher court, no? And nagfile ang PCAB now ng petition for certiorari, no, to review the decision of the RTC on the provisions, no, na tinitingnan ng RTC doon sa kanilang decision. So ang contention ng PCAB dito is that petitioner contends that it is within its duty and authority to issue the assailed IRR. Section 5 of RA number 4566 expressly confers upon petitioner, which is the PCAB now, no? Baliktad na yung petitioner dahil sila na yung nag-petition ngayon doon sa higher court ng petition for certiorari. So sabi ng PCAB dito, Section 17 of the same law empowers petitioner to adopt the necessary rules and regulations to effect the classification of contractors. Considering also that the construction business is a highly technical industry, RA number 4566 cannot by itself thoroughly address all issues and factors in the issuance of licenses in such industry. Thus, the same can only be effectively regulated by petitioner pursuant to its powers and functions under RA 4566, which includes the authority to issue the assailed implementing rules and regulations. Further, the questioned provisions of the IRR is consistent with the 1987 Constitution and existing laws, rules, and regulations and policies. The IRR does not restrict the construction industry to Filipinos, but merely regulates the issuance of licenses to foreign contractors, subject to reasonable regulatory measures pertinent to their nature of being based outside the Philippines. The questioned provisions of the IRR is consistent with the reasonable necessity of ensuring continuous and updated monitoring and regulation of foreign contractors who are distinct from local contractors, since they are not based in the Philippines and thus may be situated beyond the reach of the government for possible enforcement of the contractor's liability or warranty, such as Article 1723 of the Civil Code and Rule 62.2.3.1 of the revised IRR of RA number 9184, among others. Finally, the regulatory measures contained in the IRR are consistent with Section 14, Article 12 of the 1987 Constitution, which mandates that practice of all professions in the Philippines be limited to Filipino citizens, save in cases prescribed by law in relation to RA number 465 as amended by RA number 6511, which in turn considers construction as a profession by including contractors in its list of professionals. The IRR is consistent with the aforesaid provisions of the law in as much as the law itself recognized the distinction between foreign and local contractors. So, para kinonsider ng PCAB ang contracting business as a practice of profession. Okay? So, tingnan natin kung ano sinabi ng court mamaya, no? Kasi sinasabi ng PCAB consistent daw with Article 12 of the 1987 Constitution. Ang Article 12 of the 1987 Constitution speaks about the nationality on the practice of profession. I don't know how about with the contracting, no, sa mga contractors. So, Respondent Manila Water's argument naman is ganito. In its comment, Respondent avers that petitioner exceeded its jurisdiction by issuing Section 3.1, Rule 3 of the IRR, as the power to impose nationality requirements in areas of investment is exclusively vested on Congress under Section 10, Article 12 of the Constitution and not to a mere administrative agency. Maganda rin yung argumento ng Manila Water Incorporated. The assailed provision of the IRR contradicts and preempts statutory provisions as nowhere in RA number 4566 does the legislature authorize petitioner to impose nationality qualifications in order for an entity to obtain a license in the construction business. It is also the view of the respondent that petitioner's stance contradicts to the executive policy, which already commits the removal of restrictions in the construction industry that are evident in the following. Number 1, the Department of Justice Memorandum dated September 21, 2011, addressed to the Department of Finance, opined that the assailed section of the IRR should be amended in order to align itself with the current policy of liberalizing and rationalizing investment, as it has observed that RA number 4566 is silent as to the nationality requirement for contractors with regards to the 60% Filipino equity. Wala daw nakalagay. Okay? Participation in case of issuance of a license. Letter B, that the construction industry is not among the investment areas or activities which are specifically reserved to Philippine nationals. And letter C, the Filipino equity requirements is not consistent with the present policy of the state to rationalize investments. Number 2, the Department of Trade and Industry, DTI, and the Construction Industry Authority of the Philippines, CIAP, have recognized in an article posted in its website that for the local construction industry to be globally competitive, there is a need to strengthen the Philippine international participation through free trade agreements. Number 3, the DTI, through the Philippine Overseas Construction Board, POCB, in a construction meeting with stakeholders from the construction industry, requested for the removal of restrictions in order to establish better ties with the international trade community. There is also nothing in the Constitution or any law that imposes nationality or Filipino equity requirements with respect to the construction industry. Petitioner insists that contracting for construction is not a profession, rather than construction is an industry. It follows that it is not within the ambit of Section 14, Article 12 of the 1987 Constitution in relation to RA number 465 as amended by RA number 6511 that covers individuals and not corporations or firms which cannot be considered professionals. Ang issue ngayon dito is that whether or not the Regional Trial Court gravely erred in declaring as void Rule 3, Section 3.1 of the revised rules and regulations governing licensing and accreditation of contractors in the Philippines because, letter A, the issuance of the assailed rule is within the duty and authority of the respondent PCAB, or the assailed rule is consistent with the 1987 Constitution and existing laws, rules, regulations, and policies. So ngayon, ano ang sabi ng court? No? Ano sabi ng higher court? Sabi ng higher court, we find the petition, ito yung petition for certiorari, without merit. Hindi daw meritorious. No? So, ano kayang reaction ng PCAB? Okay? It can easily be discerned that the intention of petitioner in imposing the assailed section of the IRR is to protect the interest of the Filipino construction industry. However, the manner in which it was done raises constitutional issues on the validity of the implementing rules and regulations. The Constitution provides safeguards to protect the Filipino industry against domination of foreigners. Thus, laws were enacted to secure this state policy, particularly in areas where national economy and patrimony must be protected in our own jurisdiction. Petitioner anchors its authority to issue the assailed IRR on Section 17 of RA number 4566, which provides the board may adopt reasonably necessary rules and regulations to effect the classification of contractors in a manner consistent with established usage and procedure as found in the construction business, and may limit the field and scope of the operations of a licensed contractor to those in which he is classified to engage, as respectively defined in Section 9. A license may make application for classification and be thus classified in more than one classification if the licensee meets the qualifications prescribed by the board for such additional classification or classifications. No additional applications or license fee shall be charged for qualifying or classifying a licensee in additional classifications. A reading of the above provisions shows that petitioner is authorized to adopt rules to effect classification of contractors as may be necessary. However, the RTC observed Congress did not intend to discriminate against foreign contractors as there is no restriction that may be found in RA number 4566. Malinaw, no? Wala daw restriction, no, ng intention ng Congress to prohibit the foreign contractors. As aptly pointed out by Justice Bernabe in her concurring opinion, we should emphasize the rule in statutory construction that every part of the statute must be interpreted with reference to the context, such as that every part of the statute must be considered together with the other parts and kept subservient to the general intent of the whole enactment, because the law must not be read in truncated parts. Its provisions must be read in relation to the whole law. In accordance thereto, the phrase to effect the classification of contractors under Section 17 should be read in relation to Section 16 of RA number 4566, which provides for an enumeration of the statutorily mandated classifications for the contracting business to it. Section 16, classification. For the purpose of classification, the contracting business includes any or all of the following branches: general engineering contracting, general building contracting, and specialty contracting. These terms are then correspondingly defined in subsection C, D, and E, Section 9 of RA number 4566. Pursuant to the directive under Section 17 of RA number 4566 of PCAB law to effect the classification of contractors, Section 5.1 of the IRR on license classification and categorization subclassified the three main contracting classifications as defined in Section 9 of RA number 4566 by areas of specialization. However, PCAB went beyond the prescribed classification under Section 16 of RA number 4566 and proceeded to create the nationality-based license type under Section 3.1. Additionally, while Section 5 of RA number 4566 authorizes PCAB to issue, suspend, and revoke licenses of contractors, this general authority to issue licenses must be read in conjunction with Section 16 and 17 of RA number 4566 if the licensing power of the PCAB is to be exercised to the extent that the PCAB would be effectively creating substantial classifications between certain types of contractors. In fine, PCAB exceeded the confines of the delegating statute when it created the nationality-based license types under Section 3.1. Basic is the rule that the clear letter of the law is controlling and cannot be amended by a mere administrative rule issued for its implementation. Petitioner insists that the regulation was formed consistent with Section 14, Article 12 of the 1987 Constitution, which mandates the practice of all professions in the Philippines be limited only to Filipino citizens. Petitioner considers construction as a profession by including contractors in the list of professionals under RA 465 as amended by RA number 6511. Ano ang sabi ng court? We do not agree. The argument of petitioner is misplaced. Section 14, Article 12 of the Constitution refers to the privilege of a natural person to exercise his profession in the Philippines. On the other hand, under Article 4 of RA number 4566, even partnerships, corporations, and organizations can qualify for a contractor's license through its responsible officer. The profession under the aforesaid provisions refers to the practice of natural persons of a certain field in which they are trained, certified, and licensed. Being a licensed contractor does not automatically qualify within the ambit of the Constitution as a profession per se. Malinaw na? A contractor under RA number 4566 does not refer to a specific practice of profession such as architecture, engineering, medicine, accountancy, and the like. In fact, Section 9, Paragraph A and B of RA number 4566 reads, suffice it to say that a corporation or juridical person, in this case a construction firm, cannot be considered a professional that is being exclusively restricted by the Constitution and our laws to Filipino citizens. Licensing of contractors is not to engage in the practice of a specific profession, but rather to engage in the business of contracting or construction. The basis for petitioner's argument that construction is considered a profession is also out of context. Professionalizing the construction business is different from the exercise of profession, which the Constitution exclusively restricts to Filipino citizens. To reiterate, the license required under RA number 4566 is for purposes of engaging in the business of contracting under the terms of the said act for a fiscal year or a certain period or project. The licensee acquired under RA 4566 does not make the licensed contractor a professional within the meaning contemplated under Section 14, Article 12 of the 1987 Constitution. More telling is the fact that applicants for contractor's license are not required to have a Philippine citizenship, unlike those who are considered as professionals in the country. Accordingly, this court finds that the construction industry is not one which the Constitution has reserved exclusively for Filipinos. Neither do the laws enacted by Congress show any indication that foreigners are prescribed from entering into the same projects as Filipinos in the field of construction. Thus, we find that setting the equity limit for a certain type of contractor's license has no basis. In sum, this court finds justifiable basis to strike down the assailed Section 3 of the revised RRR of RA number 4566. Accordingly, the RTC is correct in declaring Section 3.1, Rule 3 of the revised Rules and Regulations governing licensing and accreditation of construction in the Philippines void. Wherefore, the petition is denied. Accordingly, the February 24, 2014 resolution and the February 10, 2015 order of the Regional Trial Court of Quezon City, Branch 83 or the RTC are affirmed with modifications governing the licensing and accreditation of contractors, implementing Republic Act number 4566, otherwise known as the Contractors License Law in the Philippines, are hereby declared void. So ordered by Associate Justice Alexander G. Gismondo. Okay, so pwede ma-issuehan, no, ang foreign contractors of a PCAB license, no? Hindi valid yung argument ng PCAB, especially doon sa pagsabi nila na there is a nationality principle under the Constitution, kasi that is only limited to the practice of profession. Okay? So yon, maganda yung kaso na binasa natin ngayong gabi, and hope magiging clear ito sa lahat, no? lalo sa mga nag-i-engage sa construction business. Okay? So thank you guys, and don't forget to subscribe to my channel.